Well, thank you. This is Professor John Powell. It's great to see some of you and to be a part of this really important process. I want to start by just contextualizing some of my remarks. I'm going to be talking primarily about civic engagement and voting throughout the country with some reference to California. I'm aware that some people might think that civic engagement in general and voting in particular, how is that related to enslavement? Is that a long drift away from the focus of enslavement and reparation? So first I want to just speak to that. So the 13th Amendment, as everyone knows, is what largely ended, not entirely, but largely ended slavery in the United States. There's a provision in there that allows for involuntary servitude if someone's duly convicted of a crime, which amounts to saying those people can still be enslaved. And there's a history of enslavement for people convicted of a crime up until 1945. So even though we think of this as something that happened a long time ago, there's some indication that extreme forms of enslavement happened until 1945, and some may be going on even today under the 13th Amendment. But having said that, 13th Amendment is the primary constitutional provision that changes the breadth of enslavement in the United States. And one of the things that's important in terms of the 13th Amendment for this hearing, how far does the reach of enslavement go, and how far does the reach of ending enslavement go? And what would develop very quickly, even before the passing of the 13th Amendment, was the idea of the incidence and badge of slavery. So it wasn't just formal slavery. The country, both in terms of popular discourse and legal discourse, recognized that there were some things that were incidence and badge of enslavement. Now, the exact meaning of those terms have mutated and continue to mutate. And probably one of our best sources in terms of legal discourse is Justice Harlan, who's sometimes called the Great Dissenter. And under Justice Harlan's jurisprudence, it's fairly clear that many of the issues that we're dealing with today, that he was dealing with at that time, from a jury selection, from a public accommodation, from segregation, and including voting, was considered a badge and incidence of slavery. So one could argue, so why are Blacks not oftentimes given public accommodation during Justice Harlan time? And Justice Harlan said that in of itself is a badge and incidence of slavery. So what I want to posit is that many of our voting laws themselves are also a badge and incidence of slavery. So it's not far removed. It's actually just an extension of the way we continue as a country to deny people their citizenship rights, the human rights, and to dismantle the badge and incidence of slavery. So let me go now to the 15th Amendment, which is passed in 1870. And after Congress passed the 13th and 14th Amendment, they found that Blacks still were being greatly intimidated and were not being given the right to vote. And they passed the 15th Amendment, which guarantees the right to vote and basically says someone should not be denied the right to vote based on previous servitude. So the 15th Amendment then is the constitutional amendment that enshrines voting, if you will, to actually remove the badge and incidence of slavery. When we look at voting, we find that, first of all, that passage, even though it was passed in 1870, very little was done on a systematic level to actually make sure that Blacks could vote almost up until the 1960s. So we lost 90, almost 100 years in terms of enforcing the 15th Amendment. Now, that's important because a lot of people will think, well, these things happened a long time ago. Why are we still talking about it? The very scope and purpose of these amendments did not really go into effect until fairly recently. In fact, I would say they didn't start taking real effect until 1965, the passing of the Voting Rights Act. But I'll come back to that in a minute. So I'm talking mainly about what's happening nationally, but I also want to bring California into this. So California, when it became a state, one of the things it put in this constitution, it limited voting only to white males. So again, even though it was a free state, it expressly denied the right to vote to blacks. And when the 15th Amendment was passed by Congress in 1870, only two free states opposed the amendment and initially did not ratify. One was Oregon and the other was California. So even though California was a free state, it was not a state that was hospitable to blacks. And that continued. There were a number of things California did. One of the speakers already mentioned that there were a number of sundown towns in California. And so there was not necessarily a sharp division between a slave state and a free state. Some people assume that if you have a free state, you are hospitable to blacks, and that's not the case. California was not hospitable to blacks, and especially in the context of voting, as well as other provisions. Now, in fairness to California, that started to change around World War II, and in more recent times, California has been considered a more inclusive state in terms of voting and other provisions. That's not true of the country, though. The country has largely remained hostile to blacks in terms of recognizing full citizenship and dismantling the badge and incidence of slavery. And I want to talk about some of those. Voting itself is key to being a full member of a democracy. I've written articles on that, and I'd gladly make it available to the commission. But in democracy, you can't be a full citizen, and you can't unless you can participate and vote. That's the primary good. All the other goods, from housing, education, to health, to jobs, flow from that. If that's not present, all those other things are on shaky grounds or denied as well. And that's one of the reasons that there have been so many fights over the issue of voting. So after the passing of the 15th Amendment, voting for blacks stayed almost close to zero until the 1960s. So blacks were not participating and were still living under a deep cloud of badge and incidence of slavery. On a personal note, probably like many of you, my family was from the South. They were sharecroppers. They did not participate in the formal economy, and they did not enjoy many of the things that we would have considered as an incidence of being a full citizen. They moved to Detroit in the 1940s as part of the Great Migration, and eventually achieved some of those rights, but not without a great deal of fight. So, I want to talk about the Voting Rights Act of 1965, and I want to talk about that both as a historical event, some of its problems with it today, as interpreted by the court, but also to suggest some of the things the committee might consider. So the Voting Rights of 1965 was radical in many ways. It was designed to implement the 15th Amendment. It was designed to operationalize the 15th Amendment. Now, the states had adopted a number of mechanisms to actually prohibit blacks from voting, whether it was private and public acts. But the list is too long to even chronicle at this time. But there were things like the grandfather clause. That is, you couldn't vote unless your grandfather voted. Well, if your family had been enslaved, your grandfather didn't vote. Actually, ironically, maybe your grandfather did vote because maybe your grandfather was white. But in most cases, the grandfather didn't vote. So there was the grandfather clause. There was the poll tax. Now think about this. In many parts of the South, it was illegal to educate blacks, and yet there was a poll tax taxing them. There's also the literacy test, a test given to people before they could vote. Again, if you're not educated, can't read, or don't know your history, you're not going to pass the literacy test. There were white primaries, and the list goes on. And one of the things that the Congress and the court found is that whenever they went after any one of these things, the purveyors would actually just adopt something else. It was like a whack-a-mole. You knock one thing down and something else pops up over here. And they felt they could never get ahead of it, that the states kept passing laws to prevent blacks from voting, no matter what Congress did. And so that changed in 1965. And one way it changed in 1965 was something called Section 5 of the Voting Rights Act, which required certain states, and then later extended to municipalities as well, to not change the law without getting pre-clearance if the law is going to have a negative effect on the outcome of black voting. I'm going to just restate that again. So the law was, you as a state or municipality can't change your law without getting a pre-clearance from either Attorney General or a federal court showing that your law will not have a negative effect on black voting. That the burden was on the state or the municipality that wanted to actually change their law. And so you couldn't change it without getting a pre-clearance. Now, that law was struck down largely by the Supreme Court in 2013 under Shelby County versus Holder. So pre-clearance is no longer the law of the land. And what we see is a plethora of new laws and passed all around the country prohibiting, limiting, suppressing the black vote. Now, that's just a more direct way of doing it. There's also a number of indirect ways of doing it. And I'll just mention a couple. There's something called gerrymandering, which is to draw districts in such a way that blacks can vote, but their vote does not count. You do not have essentially one person, one vote. Again, Supreme Court, under a very conservative Supreme Court, has accepted the legality of gerrymandering, which is another way of actually limiting the black vote. Another is requiring certain types of government ID. Again, just in 2020, there have been over 400 legislations introduced to limit voting, over 400 just in 2020. And this is under the backdrop of every commission that looked at it found that there was no voter fraud. There was no reason for this plethora of new laws being passed, except what's happened is the Supreme Court has weakened the Voting Rights Act and basically said to states, if you want to limit people's right to vote, particularly blacks and other people of color, we won't stop you. And they have been off to the races doing this across the country. And so we're seeing the hard-won fights over that 100-year period from the passing of the 13th Amendment, the 14th Amendment, and 15th Amendment, try to remove the badge and incidence of slavery. That wall has been removed, and we're seeing new efforts. I sort of sometimes only half-jokingly say, we're still fighting the Civil War, and the South is winning. And so I think civic participation is key. And I've only have a few minutes left, and I'll just say, while I talk a lot about voting, we can also look at things like jury duty. We can look at other ways which people participate, both to express their citizenship, but also to protect their communities. And this is one place where California has not done so well. Black participation in juries has been abysmal. And there's one study done, I think at UC Berkeley, which looked at something called peremptory challenges, which is what a prosecutor has, not prosecutor, both parties have, in terms of striking a jury. And in one study, I think over 70% of the juries struck were African American. African Americans were removed from the jury, and less than 1% of whites were removed from a jury. Now, peremptory challenge is something that a lawyer can use in a courtroom without giving any reason. All they have to say is, I don't want that juror. And what's happening in practice is a systematic exclusion of blacks from juries, largely by prosecutors. And you start off with blacks being underrepresented in the jury pool, and then those who are in the jury pool also being excluded. The last thing I'll mention, as my time runs out, is going back to voting. Again, is historically, what we've done in the country is that we've associated committing a crime with voting. And so these examples are most extreme in the South, but they're actually prevalent everywhere. And until very recently, it was also very prevalent here. And that is, even after someone has served their time committing a crime, there's some states that do not restore the right to vote. And there are literally millions, with a disproportionate number of them being Black, people who are, again, not able to exercise basic rights as citizens to vote, even after they've served their time. California recently changed that law, I think in 2020, to make it easier for someone to vote after they serve their time. So I'll end by just saying California is trending in the right direction on most things. Jury thing is pretty weak still. It's some of the stuff on the felonies, but voting is relatively accessible in California. Blacks vote at about the same rate as whites, a little less, but close to the same rates as whites. But this long tail of trying to roll back the backlash in the country is quite pernicious and has had a negative effect on both the Black community and our very democracy. And I think any serious effort to look at reparation has to look at people's right, not just what happened prior to 1865, but what's happening now, the bads and incidents of slavery that continue to be systematically implemented throughout our society. Thank you.